Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Dennis Moses, who is out of the country, and to Senator Torrell Shrikissoon, who is ill. Honorable Senators, I have received the following correspondence from His Excellency the President, Anthony Thomas Aquinas Carmona, ORTTSC. The Constitution of the Republic of Trinidad and Tobago, by His Excellency Anthony Thomas Aquinas Carmona, ORTTSC, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Ms. Alicia Romano. Whereas Senator the Honorable Dennis Moses is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Alicia Romano, to be temporarily a member of the Senate with effect from the 4th of July 2017 and continuing during the absence from Trinidad and Tobago of the said Senator Moses. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 29th day of June 2017. Honorable Senators, a senator is required to take the oath.
I, Alicia Romano, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter. Thank you.
Honourable Senators, I am awaiting another instrument of appointment from His Excellency, and when I receive it, we will revert to this item on the order paper.
Petitions, papers.
Minister of Works and Transport.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the supplemental order paper in my name. The ministerial response of the Ministry of Works and Transport to the 5th report of the Public Account Enterprise Committee on the examination of the audited accounts, balance sheet, and other financial statements of the Point Lisas Industrial Port Development Corporation Limited for the financial year 2008 to 2015. Thank you.
Minister in the Ministry of Finance. Lead of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Minister of Finance. The ministerial response of the Ministry of Finance to the 5th report of the Public Accounts Enterprise Committee on the examination of the audited accounts, balance sheets, and other financial statements of the Point Lisas Industrial Port Development Corporation Limited, PLIP for the financial years 2008 to 2015. The ministerial response of the Ministry of Finance to the 6th report of the Public Accounts Enterprises Committee on the examination of the audited accounts, balance sheets, and other financial statements of the Trinidad and Tobago Solid Waste Management Company Limited, SWIMCOL, for the financial years 2008 to 2013.
Reports from committees.
Senator Richards.
Good morning, everyone. Madam President, I have the honor to present the following report as listed on the order paper in my name. The 4th report of the Joint Select Committee on National Security, 2nd Session 2016-2017, 11th Parliament on an inquiry into prison security and the status of the investigation into the Port of Spain prison break of July 24, 2015.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the order paper in my name. The 4th report of the Joint Select Committee on State Enterprises, 2nd Session, 2016-2017, 11th Parliament, on an inquiry into the operations and administrations of the Vehicle Management Corporation of Trinidad and Tobago, with specific focus on the repair and acquisition of vehicles for state bodies.
Senator Coppin.
President, I have the honor to present the following reports as listed on the order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017. The third interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following report as listed on the order paper in my name. The 4th interim report of the Joint Select Committee appointed to consider and report on the Insurance Bill 2016. Thank you.
Senator Mark.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The 8th report of the Public Accounts Enterprises Committee for the 2nd Session, 2016-2017, 11th Parliament, on the examination of the audited accounts, balance sheet, and other financial statements of the National Gas Company of Trinidad and Tobago Limited for the financial years 2009 to 2015.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The 3rd report of the Joint Select Committee on Social Services and Public Administration for the 2nd Session 2016-2017, 11th Parliament on an examination of existing arrangements and possible options for regulating geriatric care facilities, old age homes in Trinidad and Tobago.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Minister of Tourism, in light of recent drownings at our nation's beaches and the absence of lifeguards, can the Minister indicate what measures are being taken to increase the number of lifeguards at said beaches?
Thank you, Madam President. Madam President, it is with regret that we mourn the passing of several people who drowned over the last couple of days. As you are aware, it is impossible to have lifeguards on all beaches in Trinidad. As we speak, there are lifeguard services available at Maracas, Las Cuevas, Manzanilla, Vecini, Mayao, among others. Lifeguard really falls under the Ministry of National Security. One of the drownings took place at a pool in Matura, and obviously it's hard to police all these pools in the northern ranges that are the results of waterfalls. So what we plan to do is, I saw an article in the papers today where the parents of one of the persons who drowned asked for more signage, and I think that is a very fair request, to have warning signs and to tell you the depth of the pools or where there may be rip currents and what have you. So we will take that on board and try, where we don't have lifeguard facilities, to provide the relevant signage and warning so that the population can be more careful when they exercise in their recreation on weekends in particular. But having said that, there is no immediate plan to increase the number of lifeguards that are currently on the payroll.
Senator Mark.
Madam President, is the Minister aware that the duties of lifeguards end at 5 p.m. in the evening, and with our thrust towards increasing tourism, whether the government is contemplating extending the period that lifeguard would be on duty at these beaches?
It is something to consider, especially I would have no problem in at least making a plea to extend it for about possibly 2 hours beyond 5, because 5:30 is when probably just people taking their last duck, so to speak, and a lot of things happen when you take that last dip. So it's a point that we will take on board, most definitely.
Madam President, is the Minister in a position to indicate to us what is the total complement of lifeguards in the country?
I am not in a position to so do, but that information could be easily provided.
Senator Richards.
Thank you, Madam President. To the Minister of Rural Development and Local Government, can the Minister indicate what is being done to assist residents of Northwest Trinidad who have been affected by the severe flooding over the past 3 days?
Minister of Rural Development and Local Government, you have 2 minutes.
Madam President, thank you for the opportunity to address this pressing issue that our country is facing with this inclement weather. And thank you, Senator Paul Richards, for the question. According to the reports issued by the Met Office, the country is under Code Orange, which means heavy rains and flash flooding. The Ministry of Rural Development and Local Government is in constant communications with all disaster management units of the corporations to engage in speedy response to the onset of any hazards. In the event that our situation is escalating to the level code red, which means heavy rain, severe flooding and gusty winds, the Ministry of Rural Development and Local Government will collaborate with the ODPM and other stakeholders, agencies to ensure that we launch the most comprehensive effort to tackling any issues arising. Reports coming to the Ministry over the past 3 days was street flash flooding in Port of Spain, Cascade, St. Anne's, Woodbrook, Maraval and the Gomartin areas. We are continuously working with the engineering teams of both the ministry and the respective corporations to handle these issues. We have identified the blockages, debris which wash down in water courses and have been since rectified these issues using the resources of the corporations. There were blockages in St. Anne's, Cascade, East Dry River, and Carenage water courses, which are all under the purview of the Ministry of Works. However, due to the urgency of the situation, the Ministry of Rural Development and Local Government and the corporations have acted to address these blockages.
Minister, your time is up. Senator Richards.
Thank you, Madam President. Through you, Madam President, Minister, it seems that the situation is getting worse and worse every year. In addition to rain and the debris that sometimes ends up in the water courses, unfortunately, has the ministry done any pointed research to determine the cause and contributors in addition to rain and debris, given the frequency and increasing severity of this phenomenon?
Senator Richards, I won't allow that question.
Thank you, Madam President. Is there any comprehensive plan for remediation, medium to long term?
Minister.
Thank you very much, Madam President. The Ministry of Rural Development and Local Government, in conjunction with the Ministry of Works, which include the corporation, is feverishly working on a plan to ensure that this doesn't happen every year. But no matter what we do, we always have to maintain the river courses, and the person who developing the lands are above. That's where the water course, the rivers, the debris come down into the river and cause the blockages. I saw it firsthand. I left San Fernando and came up Sunday, and I saw it firsthand, and the water ran out very quickly. Yeah, and I want to urge developers to be aware. Unlike what happened in Pinal, DB, that area, and so on. Okay?
No, that's it.
Questions on notice?
Yeah, Madam President, today I asked to crave the indulgence of Senator Paul Richards. I know this question has been deferred for 2 weeks already, but unfortunately the Minister of National Security is out of the Port of Spain jurisdiction, and he has promised to answer it at the next sitting of the Parliament. Just to say that he is in Point 14, because for the first time in the history of the country, a student of Point 14 has won the first prize in the SEA examination. Her name is Lexi Balchan, and she attended the Point 14 Asja Muslim Primary School.
I'll comply, Madam President.
Public business, government business. Motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business.
Madam President, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017, I beg to move that the committee be allowed an extension of 11 weeks in order to complete its work and submit a final report to Parliament by September 15, 2017.
Honourable Senators, the question is that the Joint Select Committee on the Cybercrime Bill 2017 be allowed an extension of 11 weeks in order to complete its work and submit a final report to Parliament by September the 15th, 2017. Those in favour say aye. Aye. Those against say no. The ayes have it. Leader of Government Business.
Madam President, having regard to the third interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016, I beg to move that the committee be allowed an extension of 11 weeks in order to complete its work and submit a final report to Parliament by September 15, 2017.
Honourable Senators, the question is that the Joint Select Committee on the Gambling, Gaming and Betting Control Bill be allowed an extension of 11 weeks in order to complete its work and submit a final report to Parliament by September the 15th, 2017. Those in favour say aye. Aye. Those against say no. The ayes have it. Leader of Government Business.
Madam President, having regard to the fourth interim report of the Joint Select Committee appointed to consider and report on the insurance bill, I beg to move that the committee be allowed an extension of 11 weeks in order to complete its work and submit a final report to Parliament by September 15th, 2017.
Honourable Senators, the question is that the Joint Select Committee on the Insurance Bill 2016 be allowed an extension of 11 weeks in order to complete its work and submit a final report to Parliament by September the 15th, 2017. Those in favour say aye. Aye. Those against say no. The ayes have it.
Public business, government business, committee stage.
Honourable Senators, the committee stage of a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto was in progress when the Senate adjourned on Thursday, June the 29th, 2017 and will now resume. The Senate will now resolve into committee. Attorney General.
Thank you, Madam Chair, and good morning to all. Madam Chair, just as a matter of housekeeping, just to indicate that I had asked the Parliament to circulate 4 documents for the benefit of honourable senators in continuing the consideration of this committee of the whole. Honourable senators should have, through you, Madam Chair, a marked up version of the bill which would show in green text the matters which we've completed by way of consideration, and also proposed in red text matters for further consideration, which relates to matters of 2 categories. Firstly, matters which we have stood down or yet to complete, and secondly, in relation to a few clauses, matters which I propose through you, Madam Chair, to ask for further consideration on, bearing in mind the observations which we reflected upon post the adjournment of the Committee of the Whole. The second document would be proposed amendments in the classic form, which is the first column, second column, as are usually circulated during committee stage. The third document would be a matter where we have considered on a landscape version, that's the manner of printing, the columns, 4 columns, 1 first column for consideration, the reason for review, the proposed amendments which we're suggesting, and then the capped-off reason for them. So honourable members would see, in relation to that landscape version, a bit of a rationale as to why we are proposing the reconsideration of a few matters and what our views are in relation to the matters which are A, stood down, and B, still yet to be considered. The last document, just for housekeeping as well, were the matters which were left outstanding for consideration on the circulated amendments proposed by Senators Ramdeen and Mark, there only being a few extra clauses left. So that, in terms of housekeeping, is where we are, Madam Chair, as we sit in Committee of the Whole. Madam Chair, for your guidance, may I inquire? We had stood down clauses 8 and 11 on certain issues of disclosure. We had paused for a reflection on clause 30. We were at last call, if I remember, at clause 30 itself, 31, with then to continue.
Attorney General, let me just tell you what our records reflect. Clauses 4 and 29 were already dealt with.
Yes, ma'am.
So it seems that we will have to revisit those two clauses. And clause 30, which you just made reference to, that was also dealt with. So is it that we are proposing an amendment to clause 30 as well? A new amendment, so that I will have that as clause to be revisited?
Yes, Madam Chair, for the issue of competence, which we had, the language in respect of which we had not certified. So whilst we had conceptually dealt with the fact that we needed to put in the reflections of competence, the specific wording coming from the drafting team, I don't think had been put forward in its final sense, so we have proposed, for completeness sake, that clause 30 do come back under consideration.
Okay. All right, honourable members, having listened to the presentation of the Attorney General, are we ready to proceed? So I think we'll start with the revisiting of clause 4 and 29. Clauses 4 and 29. So let us deal.
Should it please you?
All right, so
Clause 4 revisited.
Madam Chair.
Honourable Senators,
sorry.
the question is that clause 4 stand part of the bill. Attorney General.
Thank you, Madam Chair. Madam Chair, the drafting team brought to my attention, for consideration by honourable members of this committee, a distinction in the phrases "in the interest of justice" versus "for the good administration of justice." And the proposal for treating with clause 4 in a reconsideration sense is solely for that distinction to be factored. It's proposed that we do take care of the amendments which are shown in green as circulated in the draft marked up bill. We've been through that in the committee. But I'm asking for consideration the views of the honourable members of the Senate as to whether we should, instead of keeping with the phrase "in the interest of justice" in clause 4, as the Senate had considered, if we could shift to "for the good administration of justice." The argument coming from the drafting team is that whereas a ground for setting aside a plea agreement can be placed in the phrase "in the interest of justice" as a ground for setting aside or for appeal, that when one was considering what one should do in entering a plea agreement, that a plea agreement should consider instead "for the good administration of justice," because it may not always be the case that a plea agreement is entered into in the interest of justice, but that instead it is done to facilitate the quickening of justice, which is the good administration of justice. So a plea agreement, for a stated purpose, according to the drafting team, is that it should be done for the good administration of justice, which is separate from the concept of "in the administration of justice," where you can set aside a plea agreement. I welcome, of course, the views of the members of the Senate, through you, Madam Chair, on this particular suggestion.
Honourable Senators.
I'm wondering if there's some learning which makes a distinction for the benefit of the Senate, if there's learning which shows a marked difference between the words "in the interest of justice" and the words "for the good administration of justice," if we can be edified.
Madam Chair, I looked for learning on the point. Because some of the jurisdictions that we're referring to really deal with this on an informal basis, I couldn't come across something which had specifically defined, in terms of a judicial consideration, a distinction between in the interest of justice versus for the good administration of justice. But what we did come across from a policy perspective was that it is more that these agreements are fashioned to facilitate an administration of justice from a process point of view, and then if there is any turpitude, that it's considered on the grounds to set aside, withdraw, or appeal.
Can I ask then where the words "for the good administration of justice," in terms of a precedent, where those words were lifted from?
We lifted it from the Canadian law reform perspectives.
Okay.
Thanks, Madam Chair. Madam Chair, through you, to the Honorable Attorney General. My understanding is that the good administration of justice really comes from a public law background with respect. It is one of the omnibus phrases that are used, especially in the delay provisions under the Judicial Review Act. And I don't, respectfully, through you, Madam Chair, don't quite agree that when, with respect to the reason for the review, that a plea, it says, however, it is arguable that plea agreements are by their nature not in the interest of justice. I want to be cautious about that, and I think we should be cautious about that, because whereas one can understand that there is a difference between the terminology, I think all agreements that are entered into ought to be in the interest of justice, and the distinction or the practical distinction that one may be foregoing the prosecution of someone. I think that even in foregoing the prosecution of someone, it is in the interest of justice that we're doing that, because we're doing that in the advancement of prosecuting someone else or for the advancement of the criminal process. I would have thought that if we had used in the interest of justice, it would have been a more one is wider, you're correct. But secondly, I think that the good administration of justice falls more on the procedural line. And I think what we're doing here is really interfering or determining the way in which we proceed, not only procedurally, but affecting the substantive rights of persons. And I would have thought that in those circumstances, we use the phrase that would be wider in capturing what we are doing, which is in the interest of justice. And I think that I think we should be cautious that when we treat with matters like these, especially in the criminal jurisdiction, dealing with the prosecution of people, that we are careful that whatever we do at the end of the day should be labeled in the interest of justice to all of those involved, whether it be the accused, the administration of justice itself, or the victims, as we've done in this road. So that would be my suggestion.
Solomon?
Yeah. Through you, Madam Chair, to the Honorable Attorney General. I agree with my fellow senators. Also, I want to add that it's because there's a large amount of jurisprudence, in particular in our jurisdiction, in relation to this criminal process. The interest of justice is a better protection for the entire process. And as such, I think that I can understand where the Honorable Attorney General is coming from. But I think that for all parties concerned, in particular the person who enters into this plea agreement, the interest of justice is a protection that is necessary.
Senator Sturge?
Through you, Madam Chair, as I understand it, when one is dealing with accomplices vel non generally, and quite apart from accomplices vel non, the term "in the interest of justice" is used across the jurisprudence of the criminal law, and for good reason. When one uses the term "in the interest of justice," as Senator Ramdeen has said, it it is wider, and it also takes into account that it is not one-sided. If you are looking at the good administration of justice, that is very limited, whereas where we are dealing with accomplices vel non, as in the case of this statute, what is paramount is what is in the interest of justice, as the cases have decided, because it is in the interest of both the accused and the fair administration of justice. So I'm wondering if the common law cases you may have looked at would have given some explanation as to why they have developed along the lines of in the interest of justice.
Attorney General.
First of all, may I thank honorable senators for their very carefully put considerations. It is out of deference to the CPC's team, and certainly the experience in the team, that I felt compelled to bring this to the attention of the Senate so that we could at least consider it on the record when we're looking to pepper and heart aid to the statutory interpretation. My own personal view is coincidental with Senator Ramdeen's. I actually think that in the interest of justice is a wider catchphrase and includes the procedural safeguards that the good administration of justice. But I felt that it was a repeating loop that had to actually have it. But I certainly do want and appreciate, through you, Madam Chair, the views of honorable senators on the point. To answer Senator Sturge's inquiry, the common law cases pretty much are a blur insofar as the literature that arises out of them. I haven't considered an actual common law case itself, but we've looked at the literature behind it. And I think that Senator Ramdeen and Senator Solomon and Senator Sturge captured the overall parameter. I think that we're in a better place, Madam Chair, for having had the fulminations on the record. And unless Senator Choate or any other senator had a point of view to the contrary, I'd actually then move away from the expression for the good administration of justice.
So that are you going to withdraw the proposed amendment?
Yes, Madam Chair.
So, honorable senators, the question therefore is that clause 4 stand part of the bill. Those in favor say aye. Any against? The ayes have it. Clause 4 now stands part of the bill.
Clause 8.
Honorable senators, the question is that clause 8 stand part of the bill.
Madam
Attorney
Chair.
General, yes.
Thank you, Madam Chair. Madam Chair, we had entered into a very important discussion which resulted in a consideration of both Clause 8 and Clause 11 side by side. And it really had with the grounding of the issue of disclosure. The reflections shown for consideration of Clause 8 really require us to now consider almost side by side this position. Clause 8 specifically really now proposes that the prosecutor should not initiate or participate in a plea discussion or conclude a plea agreement that requires the accused person or suspect to plead guilty in an offense not disclosed by the evidence. That's at Roman 1 of subclause 8A. And then we went into doesn't adequately reflect the gravity or provable conduct of the accused person or suspect unless in the discretion of the DPP the charge is justifiable having regard to the benefits that will accrue to the administration of justice or the protection of society from the prosecution of the accused person or suspect, or requires the prosecutor to withhold or distort evidence. The material aspect of this consideration is A Roman 1, which is the is not disclosed by the evidence. We looked to see whether we should have treated with the qualification or consideration of what the disclosure of evidence should be, and we felt that we should maintain the separation of the nature of disclosure into Clause 11, but we've sought to amend Clause 11, as you'll see later when we come to look at it, by adding into Clause 11, I should say, by putting into Clause 11 a better description of the state of the common law as it is right now into statute. So we propose, Madam Chair, in Clause 8, to maintain the parameters for the prosecutor's inability to participate in a plea discussion, setting out the reasons as we have here. We believe that the reasons are fairly widely stated, and we deal specifically with the nature of disclosure in Clause 11 as contemplated. This does require, of course, Madam Chair, honorable senators, to consider, first of all, the policy in maintaining the separation. We just think it cleaner from a drafting perspective, but I'm, of course, wide open to receiving honorable senators' views on the matter through you, Madam Chair. I don't know if it's opposite to the best interests of the Senate to facilitate the discussion both between 8 and 11. Insofar as that might be the case, would you permit me, Madam Chair?
Just bearing in mind that the question has been put with respect to Clause 8.
Correct.
And if, we try to keep it as clean as possible for the records. So you're free to discuss Clause 11, but remember that ultimately we're dealing with Clause 8.
Understood,
Okay?
Madam Chair.
Yeah.
Insofar as Clause 11 materially affects Clause 8, if I could just flavor the discussion by pointing out that we propose at Clause 11 to qualify the disclosure both in subparagraphs 1 and 2 such that there is a general requirement for disclosure of evidence in a written summary, and that it must include the evidence that favors the case for the suspect or injures the case for the prosecution. I took the opportunity to reflect with the Law Association on the view, and the recommendation coming from the Law Association was the terminology that I've just read, which is that if a plea discussion is initiated, that there must be disclosure by a written summary of the evidence against the accused or suspect, which includes the evidence that favors the case for the suspect or injures the case for the prosecution. I know that honorable members had suggested on the last occasion that there should be full disclosure of every matter.
Just 1 second, Attorney General. Whoever has that device that I just heard, I would ask you to just step out of the chamber, seat it, and you can return in 2 minutes. Continue, Attorney General.
Yes, Madam Chair. So the deliberations on the last occasion included a suggestion that there be a blanket statement for disclosure of all evidence. The discussions which were had in relation to this bill in the policy work that brought the bill forward, etc., didn't go as far as a full statement of all evidence. And in the balancing of the considerations, the government proposes that we consider and certainly discuss that we keep with the common law standard as expressed in the Clause 11, which we'll come to in a while. May I invite reflections through you?
Senator Sturge.
Madam President, I believe I may not have expressed myself as clearly as I ought to have expressed myself on the last occasion. I see in the amendment there's reference to what is the test of disclosure at common law. Now, the focus at this point should be on Clause 11, keeping in mind, of course, with what the President has indicated. But what I see appearing now, by way of amendment in Clause 11, is the test at common law with respect to disclosure generally. And generally, what is to be disclosed would be evidence that favors the case for the accused or suspect, or the word really should be undermines the case for the prosecution. But I think, and maybe the Law Association missed it. Well, it's obvious that they missed it, because what I argued on the last occasion was this, and I understand why the Attorney General was hesitant. The Attorney General did not want a disclosure regime under this statute that was different to the common law, and I understand that. But what this amendment does is actually undermine what the common law is with respect to accomplices vel non. Generally, the amendment circulated here applies to the rules of disclosure generally at criminal law. But when you are dealing specifically with an accomplice well known, the rules of disclosure move past the general common law rules, which is evidence which favors the case for the suspect or undermines the prosecution. And at common law, the rules of disclosure with respect to the accomplice well known is full disclosure because of the nature of the person you are dealing with. So if the DPP decides that he's not proceeding under this act and he's proceeding at common law where he gives an immunity, either absolute immunity or conditional immunity to the accomplice well known, the DPP at common law has to give full disclosure. He has to give to the defense everything, every utterance and every statement that was given by the accomplice well known. But this amendment put forward actually takes away from what the common law says. Yes, it is common law disclosure, generally, these rules. But when you are dealing with accomplices well known, the common law rules that apply generally do not apply. The common law rules specifically dealing with accomplices well known requires full disclosure. So all I'm asking, I'm not asking for two regimes. I'm asking that this statutory regime be on par with what the common law is, which is full disclosure.
Thank you very much, Madam Chairman. My concern is a little different from that of Senator Sturge, even though I do see the importance of the point he has made. I am looking at what is required to be provided to an accused person in terms of disclosure, and 7(2) of the Criminal Procedure Rules says that the complainant must serve initial details of the prosecution case on the court officer and so on. And the content of these details are set out in 7(3)(1), which I suppose we could call the disclosure rule. A says initial details of the prosecution case must include A, a summary of the evidence on which that case will be based, B, any document or extract setting out facts or other matters on which that case will be based, or C, any combination of such a summary, statement, document, extract, or criminal record, if any. So already we see that there is a distinction between the application of the procedure as to how to deal with disclosure in the summary courts as set out in the rules and as set out in this proposed piece of legislation. I'm trying to look at the rules to see whether there is anything different with respect to, oh, here we are. Rule 14. It says, directions given by the court pursuant to Rule 10 should include fixing a date by which the prosecution must disclose to the accused all the evidence they intend to rely upon at trial, fixing a date by which the prosecution must disclose any material in its possession that they do not intend to use at trial, which materially weakens the prosecution case or assists the accused, and fixing a date by which the prosecution must confirm if any material in its possession that they do not intend to use at trial, which materially weakens its case or assists the accused, has been served on the accused. And the 14(2) says the prosecution shall disclose material under 14(1) unless the magistrate or judge orders that such material should not be disclosed in the public interest. So it seems as though there is a pretty wide or deep, I should say, responsibility given to the prosecution by these rules, which will govern the way cases are administered in summary matters and indictable matters. And I would suggest very humbly that there should be some sort of compatibility with what we are creating here and these rules.
I think I may have a solution, Madam Chair. Thank you, honourable senators, for providing us with the benefit of your expertise in the area of law. I think we've done well to paint what the mischief to be avoided is, which is non-compliance with the laws in relation to disclosure, both in terms of written law and the common law, and specifically also not to cause, in the creation of this law, different regimes for the compliance of disclosure. Perhaps it may help, and I'm just thinking aloud here, subject to the drafters, because I haven't yet given them this thought, if we were to attenuate the language, amend the language at 11, as it'll be incorporated into 8, to say that the attorney, you must provide the attorney at law with a written summary of the evidence against him, including the evidence that shall be disclosed both at common law and or under any written law. Something to that effect. It would allow us to maintain the common law provisions as they evolve, and or the catching of written law would allow us to take care of subsidiary legislation as well, which rules are pursuant to the Supreme Court of Judicature Act. So if honourable members are okay with the concept floated, I could ask the drafters to tighten that language. That is, that we give the written summary as we've indicated, but that the evidence to be disclosed should comply with written law, which should take care of rules, and also the common law.
I was wondering if perhaps 11.1, we can insert the words after a written summary of, we can put all of the evidence against him. And that would be in keeping with what is the common law position. If I may explain the position, because at common law, the prosecutor is the person providing the immunity and so on, and therefore he's a party, in essence, to the proceedings, then and again, because of the nature of the person who is making a deal and gets a benefit, hence accomplice vel non, that is the reason why they have removed the discretion from the prosecutor, which exists at common law generally, because at common law generally, the test to determine whether something is disclosable is a test that is carried out by the prosecutor, and the prosecutor determines, in his view, whether evidence advances the case for the suspect or undermines the case for the prosecution. So whilst generally at common law, the prosecutor makes this decision, when you are dealing with an accomplice vel non, they've removed that discretion from the prosecutor, and therefore all evidence in relation to the accomplice vel non is disclosed. So perhaps Senator Ramdeen may have a better way of wording it, but I see we may get some distance if we insert the words summary of all of the evidence against him.
Thank you, Senator Sturz. Through you, Madam Chair. My alarm bell just rings on the concept of all evidence if I work my way outside of the vel non scenario.
No, it wouldn't apply to outside of the vel non scenario. This here deals specifically, 11.1 narrows it down substantially by saying what you are dealing with is a suspect. So the subject of 11.1 would be the suspect and his attorney. So you are disclosing to the suspect and his attorney and no one else. And you are not disclosing evidence at common law generally. You are disclosing to him because of the circumstances in which he finds himself as a possible accomplice vel non. And in those circumstances, by way of interpretation, it must be limited to the rules of disclosure with respect to accomplices vel non. It must be limited to the situation. It wouldn't extend across the board. By putting full disclosure in disclose, it doesn't necessarily mean, in fact, it doesn't mean at all. One would have to embark on serious mental gymnastics to stretch it to say that it discovers, it stretches to disclosure generally. Because what you are dealing with here specifically is just the accomplice well known, unless the drafters have a different view. That you don't end up disclosing what a suspect that they are accused. You won't get to do it to disclose. When you come to 3.
Madam Chairman, I listened to the proposal of the Honorable Attorney General, but I'm of the view that the formulation is a bit too wide for it to work. And I think the exercise we should be engaged in is trying to pull the words of the legislation closer to other written law as they exist. And the reason for this is, at common law, for example, disclosure at a committal stage or preliminary inquiry stage would be in the hands of the prosecutor. The magistrate has no power there. In a summary trial, the magistrate has the power. At the High Court, a judge can make an order upon an application for disclosure of relevant material which the prosecution has not handed over. So it's a bit difficult to look at the common law to say that whatever is disclosable according to common law should govern any fact situation. So what I'm respectfully suggesting or proposing is this, that after the words written summary, we have the words of the relevant evidence, including any material in the possession of the state which materially weakens its case or assists the suspect or accused. So it brings it in line with the existing criminal procedure rules.
I thought you had
I
it
can
written down.
try.
Which materially weakens the
Its
case
case,
of the state.
the case weakens its case, meaning the prosecution's case, or assists the accused. Because this is what currently you are entitled to under the criminal procedure rules when you go before any judge or magistrate.
Madam Chair. Thank you, honorable senators. My initial reaction before the gear kicks in on the intellectual level is the use of formulating into the parent law now, this principal piece of law, something which is essentially subsidiary legislation, which are the rules, because the rules are subject to change and evolution as the courts progress, by a relatively easy mechanism of negative resolution as the Rules Committee shape over time. Clause 36 of the bill itself allows for the Rules Committee, well, we propose that Clause 36 be amended from what is actually here. We had taken up the invitation of the opposition in the House to put the minister to create rules. On reflection, we believe that that Clause 36 should in fact be amended to allow for the Rules Committee to make rules. So I'm wondering if there may be a danger in using the current terminology of the rules themselves, Part 17 of those rules, in the parent law. And I'm also wondering, perhaps you can help me to think this through, Senator Choate. I'm wondering about the inapplicability of the common law stroke written law approach. Could it also help us that the common law would assist us at the various stages. That is the distinction between prosecutor, summary court, and high court. Because wouldn't it then fall to reason that it is the common law at the respective stage that would apply? The drafters had actually passed to me a version for reconsideration which could read as follows. In clauses 11(1) and 2, insert after the words "against him" the words "including the evidence that the..." I understand. Sorry. But this would have to be amended because it now speaks to only the prosecutor, right? Including the evidence that the prosecutor is required to disclose by the common law or any other law. The things to pull out of this would be A, reference to common law across the various stages, but B, the any other law would catch the rules as they evolve from time to time. I'm a little bit cautious about formulating the present terminology of the rules, mainly because we're still working out the rules in terms of practice. I believe that there's a gap between what the rules actually say right now and what they may settle into, if I were to borrow from the experience of the civil proceedings rules themselves, which evolved over time to settle a little bit more the gray areas of practice. May I ask for deliberations on this, Madam Chair?
Well, Madam Chairman, if I may, we still continue, we still have the problem with the articulation of two regimes for disclosure, which are not the same. So we have a written summary of the evidence, and then we have the inclusion of what the prosecutor has to disclose according to common law and according to any other written law. Well, it would mean that if a case, it doesn't fall under the rules for management, let's say the judge or magistrate decides that the rules will not be used in the management of this particular case, you must have something to fall back on, because judges and magistrates are less likely to use the rules for case management for guilty pleas, simply because the process is much quicker. So you need to have in the legislation a clear definition of what you intend to be considered as disclosable material, so that the judge being called upon to make an order under this regime will have a clear idea. I don't know if I'm making sense. I hope I am.
Yeah, I think that the intention is that the policy, if I could put it that way, of the proposal is understood, and I thank you for it, Madam Chair. Madam Chair, may I ask now, having had that discussion, it seems to me that we could cleave Clause 8 from Clause 11, because the mischief that we're really speaking to is going to reside in Clause 11. I think that Clause 8 as drafted is safe, because 11 filters into 8. And I propose that we work on some wording, now that we've had some more fulminations from the Senate, on an improvement to the language of Clause 11. May I ask, through you, Madam Chair, whether the Senate considers that we still need to bind consideration of 8 and 11 together? Or can we press on with 8, pause on 11, and then perhaps tidy up with the rest of the considerations we have? Subject to your view, Madam Chair?
Members, the question that was posed was in respect of Clause 8. Can I now therefore put the question? So the question is that Clause 8 be amended as circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 8 as amended now stands part of the bill.
Clause 10.
The question is that Clause 10 stand part of the bill.
Madam Chair, I wish to thank honourable senators for the very excellent discussion we had on Clause 10 on the last occasion. We had agreed to expressly provide for the cautionary activity of the prosecutor informing the accused person of the various rights, which we have faithfully set out in the draft circulated, by improving that to include Roman 1 to Roman 7. We've also dealt with the caution as it repeats a little bit lower down. What was outstanding, sorry, with respect to the suspect, so you see that in subclause 2 where we've now repeated the rights. What would be missing in the difference between the rights expressed as needing to be told in the suspect case versus the accused case would drive squarely in the Roman 6, because we've left out the sentence indication, because at the suspect stage we didn't need to repeat that there. When you came to actually being charged, that would kick in, so that's the difference between the two. But what we've added in here is the concept of competence in particular, which was something that we had expressed a view needed to be established by the court. So Clause 10, I believe, now captures the deliberations which we had on the last occasion. I, of course, through you, Madam Chair, welcome the views of senators as to anything that the government should consider further on this clause.
Members, we are dealing with the Clause 10, the amendments circulated. Senator Ramdeen.
Madam Chair, Attorney General, through you, Madam Chair, Attorney General, I would like you to consider in Clause 10, 1A, the prosecutor has informed the accused person, and then you have a list. You've included all of the rights that we've suggested. We have had the occurrence with respect to the right to be informed of the courts extending the right to an attorney to the right to be informed of an attorney on the basis that informing somebody that they have a right to an attorney may not capture the policy that the Constitution wished, or the protection that the Constitution wished to give to that person. Because the mere fact of saying you have the right of an attorney without knowing what that right or what the content of that right entails really means nothing. I was wondering whether you would consider, after the words informed, the prosecutor has informed, if you would consider inserting thereafter the words unexplained to. Because the classic example of that is that we have an express right not to self-incriminate under the Constitution. I don't think 9 out of 10 people in this country understand what that means. So by simply telling someone, and you could understand in the situation that we currently exist in, a prosecutor telling someone you have the right to be represented by an attorney of that law, you have the right to protection against self-incrimination, and the person has absolutely no idea what is this. It really doesn't flesh out the protection that we wish to give by the clause. So I was wondering whether you would consider adding in the duty to just explain to the person what that right is.
Madam Chair.
So just 1 second. Before Senator Ramdeen has made his comments, are there any other comments on the proposed amended clause?
Madam Chair, on the very last subsection, to the plea discussions being recorded, from my recollection, we had a discussion that there needed to be some clarification with respect to whether it was going to be audio, video, digital, or both, and it remains hanging. So I need to get some kind of feedback from the Attorney General with respect to what is the appropriate recording mechanism that we are now going to recommend to the court for this particular pre-discussion. Thank you.
Senator Choate.
The defense attorney, Madam Chairman, side of me tells me that I ought to fully endorse the proposal suggested by Senator Ramdeen. The prosecutor side of me is saying that perhaps we are edging into being too prescriptive I mean, we can't expect the prosecutor to do more than simply be a minister of justice in these circumstances, which will include, depending on the case, an explanation. But to say that it must be given in every single case, I think that is not appropriate. It is not in sync with the law, generally speaking, because you don't have any explanation required under the law of your rights as a general rule. So I don't know that it's necessary in this case.
Madam Chair? Yes. Thank you, Honourable Senators. Through you, Madam Chair. Yes, please.
Excuse me. AG, before you respond, just following from the comments made by Senator Choate, perhaps you would want to consider in your response that there is a right under Section 52H of the Constitution, which is where the white man principle was grounded in, that you have the right to such procedural provisions to ensure that the rights that are conferred by Section 4 and Section 5 are given effect to, which is the general omnibus clause that you have. But it does have a substantive element in that clause that procedural provisions is defined in Whiteman as being any provision that will allow that right to be better enforced. So,
Attorney General, Senator Choate.
Yes, Madam Chairman, and the thing is, how that operates in real life is that it means you can't put up a sign on the wall and say that this is your right. You have to have some indication or record that the police officer has told the person that he's entitled to have an attorney at law, friend or relative present, for example, if he's going to take a statement from him and so on. So, as I say, I mean, I am simply making the comment that it may be considered overly prescriptive. At the end of the day, it's a policy decision as to how the government wishes to proceed.
Attorney General. Senator Mark, yes?
Yeah.
May I just, though, before Senator Mark makes his intervention, what I am trying to achieve in committee stage is, as we go through with the clauses, I'm trying to let everyone who has an issue raise the issue, and then the Attorney General will address it, so we don't have this to-ing and fro-ing, because we need at some point in time to settle on what we are doing. Senator Mark.
Yes. Yes. Madam Chair, I wanted to ask the Attorney General, how would we be treating under this clause 10 with those persons who might be physically challenged, who mentally challenged, I should say, and who are very vulnerable? What kind of safeguards are we going to be establishing in this particular clause to provide them with some comfort in terms of their rights? And Madam Chair, if you recall, we were referring to the whole question of psychiatric evaluation at the last sitting, right? So if you could probably tell us where and how we are going to address that, Madam Chair, I'll appreciate it.
Thank you, Madam Chair.
Senator Sturge.
I just had one suggestion. I believe it's under 10(1)A, which is different to what has been advanced. I was wondering perhaps if 10(1)A can be amended to read, the prosecutor has first informed the accused person. And then Roman numeral 1 to 7 would follow.
Attorney General.
Thank you, Madam Chair. Okay. In terst format, there are 3 substantive issues. Well, 4 positions, if I recap them. One is this concept of explain as a qualifying, perhaps prescriptive element to information. 2, the issue of recording raised by Senator Mahabir. 3 is the issue of competence, if I put it that way, physical, mental, or other capacity issue. And 4 is the suggestion by Senator Sturge that we improve the organization of words and qualify them in in 1A. May I start with the concept of explanation? I shared the same view that Senator Choate expressed on the need for caution as to information versus explanation. And what really jumped out at me was, when is an explanation going to be deemed to be adequate? Who is the qualifying entity to say that an explanation in the nature of this accused was an adequate explanation? That flows into the concept of competence. Senator Mark, what we did to answer the issue of competence, you'll see in 1C, that is, the proposal is that the court has been informed of the matters set out in A and B. That is, the information with respect to rights, etc., having been put to the accused, he being informed of it. B, that the accused then elected to go in a particular route. And C, what we're saying here is the court not only has been informed of the matters that I just referred to, but is satisfied that the accused person is competent to enter into plea discussions and conclude a plea agreement. The use of the word competent there catches all of the elements of competency, that you're physically and mentally, and in terms of age discretion aspects, competent to be making the decision that you've made. So the court has that supervising role to ensure that the vulnerables are caught in the situation. It arose directly out of the recommendations that Senator Choate had put to us on the last occasion, and indeed in her debate itself, and repeated by Senator Ramdeen as well and Senator Sturge. So I think that we can safely feel assured that competence is there. Relative to Senator Mahabir, the concept of recording, we deleted actually the concept of recording for the accused person on the recommendation of Senator Choate. We've kept it in respect of the suspect. The intention there being that it's a safeguard because that suspect is not quite yet in the category, maybe perhaps viewed to be a bit more vulnerable than an accused person. The question as to whether it's going to be audio recorded, visually recorded, etc., would be to condescend into specificity on technology. Many years ago, the only way you could record something was by written hand information, which then evolved into audio recording, which then evolved into video recording. And then one ought to prescribe oneself against being technologically specific as to the methods by which recording can happen. So we've just said recording. It takes care of the vicissitudes as to the availability of specific equipment at that point in time. Remember, evidence is always considered by the court, firstly as to whether it is admissible, and secondly, what weight the evidence will carry. Because it isn't that every piece of evidence that is admitted is given the same weight. Hearsay evidence is different from first-hand evidence and carries a different weight. Circumstantial evidence is different. So the court takes care of the balancing exercise. From a government policy perspective, I prefer not to qualify, even though I understand Senator Ramdeen's good caution as to it has been explained. I'm fearful of opening the door a little bit too wide on the explanation being adequate or not in the circumstances, and I prefer that we consider that the court, in its supervisory function of considering the competence of the accused and the fact that the court is being bound to consider that the accused or suspect was made aware of rights, that can be factored out in the balance. Senator Sturge offered a formulation in respect of 1A, which is that the prosecutor has first informed the accused. I think that flows from the fact that the court had to be informed in any event. When we looked at the language of C says the court has been informed of the matters at A and B, and therefore it flows from that you had to have a first information. You had to be informed first, because then the court is told, well, I did inform. So I think it flows naturally there. In all of the circumstances and in the round, I'd prefer not to include explanation. I believe, Madam Chair, that Senator Ramdeen may have a further view for me to consider.
Well, just 1 second. Is that correct?
Yes, Madam Chair. Yes. Madam Chair.
Yes.
Yeah. AJ, would you consider, instead of the formulation that I suggested, I just looked at Whiteman and I was wondering whether you would consider after the word person, so it reads the prosecutor has informed the accused person, and you add the words there in a manner that he understands it. That comes straight out of Whiteman, instead of putting a burden of having to catch whether it was explained properly or not.
Madam Chair, I thank Senator Ramdeen for that further consideration. Again, I come down to the express statement in the parent law of something which the common law can take care of in its deliberations, and which the court would have to satisfy itself of when it gets down to the issue of competence or understanding of the accused. I think that the law can work itself out that way. I do understand the good intention behind the submission, but if it's a matter of decision at this point, I'd prefer to leave it the way it's expressed, but I do welcome the thoughts. In all the circumstances, we're proposing that the clause as circulated, subject to your putting it, stand part of the bill. I don't know if there's anything else to discuss.
With the indulgence of the Chair, AG, I'm still not satisfied and happy with the kind of circumstances that vulnerable persons can be exposed to, even though you directed us to the section that deals with the competent and the court. I'm dealing with the situation prior to the court being informed. And if you have, for instance, persons who are vulnerable and they don't have representation, all kinds of activities can take place at that point. And then the court will be informed subsequently of these developments. So it doesn't take away from the critical importance of ensuring that those persons who might be vulnerable, whoever they may be, mentally challenged, physically challenged, juveniles, how do we ensure that they are not compromised at the early stage before the court is informed? I'm not seeing any provision there to safeguard those persons.
Madam Chair, thank you, Senator Mark. I understand the mischief that you're trying to protect against. May I assure you that the vulnerable in certain categories are dealt with under other pieces of law. For instance, juveniles, you must have a child advocate attorney present. That is now a feature of our law since 2014, so that's been introduced. In respect of persons with diminished capacity, etc., when the court is conducting its consideration or analysis of competence, it's at that point that it does flow backwards and it may vitiate all events, so it is void ab initio potentially. In respect of persons with physical incapacities, etc., a physical incapacity doesn't necessarily affect your competence. It may affect the manner in which things work themselves out. But I feel confident that the supervisory jurisdiction of the court on the consideration of the inherent principles of justice can manage the situation. But rest assured that there are other articulating laws which work together with this, and that it's not legislatively the course to follow that you provide for every single example there. That word competence in and of itself is a very powerful concept for the court to consider.
Honourable Senators, the question is that clause 10 be amended as circulated. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Honourable Senators, the question is that clause 10 as amended now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Clause 10 as amended now stands part of the bill.
Clause 11.
Could I ask you, Madam Chair, to defer clause 11 for a while?
So clause 11 is deferred, stood down. Move to clause 31. Oh, 29. So we now revert to clause 29.
Clause 29.
The question is, Honourable Senators, that Clause 29 stand a part of the bill. Attorney General.
Madam Chair, we had stood down Clause 29 on the last day to address the issue with respect to the quote-unquote right of the DPP to appeal.
All right, let me just stop right there. We are actually revisiting because my records show that we had, in fact, amended Clause 29 in terms of the 14 days, the time frame, to 28. And so that we are actually now revisiting Clause 29.
My record didn't reveal the same, Madam Chair.
Yeah.
We did amend the time frame,
Yes.
but then we went into a substantive discussion as to whether the leave aspect dealt with the core aspect of whether there was an actual right to appeal, because there wasn't a pure right of appeal expressed.
Okay, well, yes, we have it recorded that it was put to the as amended standard.
I'm corrected then.
So I need now to just.
Sure.
We are now revisiting it.
Thank you, Madam Chair.
Yeah. Attorney General.
Thank you, Madam Chair. Madam Chair, thank you for the guidance on the record. Clause 29, after having been considered, put and voted upon, an important issue arose on the floor of the committee, which was whether we needed to better express the right of the DPP to an appeal. We considered that, and we thought that there was definitely merit in a re-expression of the clause. We propose now, in the Clause 29 as it stands part of the bill, Clause 29 deals with the Director of Public Prosecution's right of appeal against rejection of a plea agreement. Now, I should point out, 28 dealt with the accused person, the right for the rejection of the agreement. Clause 29 then went to the other side of the equation, which is the DPP's right for an appeal against rejection. Clause 30, which we'll come to, dealt with the grounds for withdrawal, and it was mixed with an appeal by the accused person. 31 then dealt with the application of the prosecutor to set aside conviction or sentence. And then 33 dealt with admissibility, etc. So we were dealing with, if there's a rejection, what happens on either side of the coin, accused versus and DPP. If there was something to the core of the agreement in the High Court, what happens on either side? And then if there was something that dealt with the core of what should be appealed. So we dealt with the various stages. In 29, we're proposing that it be redrafted, that we delete subclause 1, which said the DPP may appeal to the Court of Appeal against the court's rejection of a plea agreement, and instead we put the DPP may, with leave of the Court of Appeal or a judge thereof, so that deals with both the chamber and full court approach, appeal to the Court of Appeal against the court's rejection of a plea agreement. And that in subclause 2, where in accordance with subsection 1, the DPP is granted leave to appeal, the DPP shall give notice of appeal in the form set out as Form 10 in the schedule within 28 days, not 14 again, of receiving written notification of the court's reasons for rejecting the plea agreement under 25.3. There was a mistake in the old version where we had reference to 25.2, and it should have been 25.3. So we're proposing that the right to appeal be passing through a leave stage, and that find expression in the new one as circulated, and that we agree with the amendment to change the daytime from 14 days calculation to 28 days, and that we correct the inadvertent reference to 25.2 to 25.3. I welcome honourable members' views through you, Madam Chair.
Honourable Senators, the question is that Clause 29 be amended as circulated. So members,
Yeah,
members, please, may I just ask that when to catch the attention of the chair, please just put on your mic and indicate your intention to ask something. Senator Ramdin, you want to raise an issue?
Yes, Madam Chair. Madam Chair, through you. AG, in the section 28, we have the accused having the right to appeal limited to the rejection of the plea agreement.
I'm going to treat with that in clause 30.
Sorry?
So I'm going to treat with that in clause 30. So we were looking at this clause here in 29 we're dealing with is just the DPP. And this is on if the judge rejects the agreement, go and seek leave to appeal, and if they tell you yes, then appeal.
Well, why are we inserting the requirement for leave? That's the question.
Well, that came about as a result of suggestions on the last occasion. So it was as a result of the recommendations of the members of the committee that the request for a bifurcated approach happened, that there be a leave to appeal. In a sense, it fuels the argument that these agreements where there's an inequality of bargaining power, i.e. where the DPP is potentially better resourced than the average person, that the DPP be put through a certain level of, how should I say, hurdling to get there. I mean, the request for leave really did come up, as I understood it in the discussions on the last occasion. That's what I understood the request for leave to be.
I'm just concerned that where we are dealing with the rejection of the plea agreement, the accused has a right to appeal without leave, and the DPP has to cross that hurdle of leave. And it just seems to be a degree of inequality in terms of the test or the threshold that has to be satisfied by equal parties who wish to challenge the same decision, which is limited to the rejection.
Madam Chairman, if I may, I think there exists a disparity because
yes, in the 1996 Miscellaneous Provisions Act.
The DPP already has a very narrow ambit within which he has the ability to access the Court of Appeal, and that is to say where there's a no-case submission which has been upheld. So this doesn't really philosophically clash with other criminal law legislation. By putting in the leave process, you're simply saying that you have to show that you are entitled to appeal because of certain conditions being satisfied, and Section 30 preserves the right of appeal which someone would normally have in any event.
Madam Chair, Senator Choate is again spot on. We went back to the 1996 amendments in the miscellaneous provisions, and we mirrored the exact terminology of the leave approach. So in fact, I think that the bill in the original form had moved away from that, and that we would have had a different regime under this particular approach. So what we did is we went back to the 1996 version of the leave requirement.
Right, but that doesn't answer the question as to this is not
an unfettered right on the accused part versus the fettered.
No, the DPP has a right under the 1996 Act to appeal on the refusal of on the grant of a no-case submission to appeal to the Court of Appeal. That has nothing to do with this. This is limited as per the section to an appeal to the Court of Appeal, having nothing to do with a no-case submission on something that deals solely with the rejection of a plea agreement. Now, the accused has a right to appeal that finding of a court, independent of any no-case submission or the Act 28 of 1996. So that I don't see what is it that we are achieving if it is independent of the limited right of the DPP to appeal as provided for in the statute, because he doesn't have the right to appeal anything beyond that, as to why we are putting a leave provision here when we've already in subsection 1 limiting it to the rejection of the plea agreement. The right that you're giving the accused doesn't hinge on the fact that the accused has an unlimited right to appeal on a conviction. So that unless we understand that the threshold that we are inserting for leave must satisfy some purpose, What is the purpose that we're trying to satisfy that you must cross when the court comes to determine the application for leave? When the DPP goes and files an application for leave to appeal, what is he satisfying? What is the test that he has to satisfy, or that the court, what is the test that the court has to be satisfied when the DPP exercises this right?
Before the Attorney General answers, is there any other senator who wishes to comment? Senator Truitt.
Madam Chairman, I am not quite sure that I follow all of the complaints being advanced by Senator Ramdeen, and I do want to try to understand what he is saying, because he makes very valid contributions on matters such as these. I thought that one of the factors which influenced us on the last occasion was to ensure that we didn't make a plea deal less attractive. So we were saying that if you give the Director of Public Prosecutions the full right to appeal in certain circumstances, it means that the person who is pleading guilty is worse off, because if he pleads not guilty, or if he goes to trial, there is no right of the DPP to appeal anything at all. Now, I know that I had formulated what I had said based on a suggestion of Senator Heath, which is to say that if we want to make this appeal, this whole thing acceptable, or the word that comes to mind is not a word I can use in the Senate. Sorry.
Prone to usage.
Yes, absolutely. What we don't want to do is to say that, listen, if you plead guilty, the Director has the same right as you to access the Court of Appeal, to have that set aside. I thought that was a public policy consideration.
Madam Chair, I understand it from that perspective, but I understand what Senator Ramdeen is saying from the converse perspective, because this is now on the rejection of the agreement, where the court considers the plea agreement and says, sorry, I don't agree with any of you all. I'm going to reject this plea agreement. Let's go to trial. So I welcome the views that Senator Ramdeen has put forward here.
Intervene and just share with you a thought that comes to mind. The fact that the fact that the DPP may appeal the rejection of a plea agreement doesn't necessarily mean that that appeal will be adverse to the accused. It may be an agreement that the accused and the DPP have come together on, that they both agree with, and the court of its own volition decides that we are not accepting that. So it may be that both parties may be in favor of challenging the decision of the court. One doesn't necessarily have to follow that the fact that the DPP appeals is in a normal course of events adverse to an accused, which is different from the case of a conviction. You might have the DPP and the accused saying, well, we think that this is what should happen in this prosecution, and the judge saying no. So that I think it shies away a little bit differently from what would happen on a right of appeal that will flow from a conviction. There is a policy, I think it's really a policy position.
I'm with you on that. We brought the recommendation through you, Madam Chair, on account of the discussion. So this flow of recommendations came in an attempt to make our work move a little bit faster today. So through you, Madam Chair, I welcome all the views on this so that we can move to a better piece of law. We've in fact treated with the setting aside an appeal on an agreement where there's an improper motive or purpose or other aspects by a leave stage as well. On this particular point, I have no principled objection to there being no qualification on the rejection aspect, because it would A, match up to the proposal for the parity between accused and prosecution. But B, insofar as I think having had the benefit of Senator Choate's thoughts just expressed, I think that the mischief really lies, and I think Senator Choate is perfectly correct, where there can be a disadvantage in a story not ending, and therefore people may shy away from the utilization of the law. I think, however, that the ability to appeal on a rejection of the agreement can be disaggregated and distinguished from the setting aside or appeal on one which has been accepted and which either party is now doing. And that I could certainly see that we would want to have the state a little more restrained than the accused in setting aside an agreement which the state participated in, which we treat within clauses 30 go down. May I ask the question through you, Madam Chair? The government's perspective on clause 29 really can go either way. As originally expressed, the Director of Public Prosecutions may appeal to the Court of Appeal against the court's rejection of a plea agreement. That can stand as it is. I'm very concerned, bearing in mind Senator Choate's observations, and in particular her area of practice and distinguished practice, to hear Senator Choate's views on the point as to whether there is any objection in maintaining 29 as it was amended originally, and in not treating it with the way as circulated, which was circulated to catch the discussions which we had and to crystallize them. May I ask that through you, Madam Chair? Does this discussion help us, Senator Choate, in advocating that clause 29 stay as we had originally passed it?
Madam Chairman, my difficulty is I only worked with the amended version, so I'm going to have to pull it up to see what it looked like before.
So 29 read, very short subclause, 29(1), the Director of Public Prosecutions may appeal to the Court of Appeal against the court's rejection of a plea agreement, full stop. No requirement for leave at all. So the difference between 29(1) as passed on the last day and 29(1) as circulated now, because there was an undertaking to look at it on our part, is the lack of qualification, the no need for leave stage.
Sure, and does it include the reasons for rejecting the plea agreement part? Did it? 29?
No. Yes.
Yes.
2. That's subclause 2.
Right, I'm with you now.
Okay?
Yes.
Then in those circumstances, may I do two things, Madam Chair? One is to thank you for allowing us to have a fulsome discussion. And two, may I withdraw the request that we reconsider clause 29?
You did indicate that there was an issue with the 25(2), which is in subclause 2.
Yes. So
it's supposed to be 25
it should be 25(3). So that if we're reconsidering it, that the reference to 25(2) instead be 25(3). I sometimes wonder if these things can be caught by consequential amendments, but out of caution, perhaps we should do that.
All right, so the first thing we'll do is to ask you to withdraw the
circulated version, so withdrawn, and instead to propose?
Yeah, so Honorable Senators, the question is that clause 29 be amended as follows. Clause 29(2), Clause 29(2), the Director of Public Prosecution shall give notice of appeal in the form set out as Form 10 in the schedule within 28 days of receiving written notification under Section 25 sub 3 of the court's reasons for rejecting the plea agreement.
That's correct.
Deleting 3, deleting 2 and substituting 2.
So delete 25(2) and insert 25(3).
Yeah. Those in favor say aye.
Aye.
Those against say no. The ayes have it. The question is that clause 29 as amended now stand a part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 29 as amended now stands part of the bill.
Clause 30 revisited.
Honorable Attorney General. Look, the question is that clause 30 stand part of the bill.
be
Attorney
revisited.
General.
Madam Chair, first of all, I couldn't remember whether we had actually concluded the clause or not.
We did.
Okay. In those circumstances, I really wanted to just take up from the conversation that the Honorable Senate in committee had expressed. Now, as my notes show, we had deleted the write-up, the or appeal against conviction. And I just wanted out of certainty to confirm the following. In clause 30, as I had it, we deleted or to appeal against conviction or sentence based on plea agreement.
Yeah.
And we added in, there are any other grounds upon which the plea agreement should be set aside.
Correct. Yes. And you deleted.
Right, so I'm just double checking here.
And you took off
Just
the
allow me one moment.
Yes.
Madam Chair, having confirmed, not having had the benefit of the Hansard, that we have made those amendments, may I invite that we leave the clause as it is? It was just out of caution that we had raised it.
So the questions, Honourable Senators, is that clause 30 now stand part of the bill. Those in favour say aye. Aye. Those against say no. Clause 30 now stands part of the bill.
Clause 31.
The question is that clause 31 stand part of the bill. Attorney General.
Madam Chair, clause 31 was quite an interesting one, or is quite an interesting one. We were dealing with clause 31 providing for the application of the prosecutor to set aside the plea agreement, conviction or sentence. And in 31, we said, notwithstanding an accused person's conviction and sentence pursuant to plea agreement, the DPP may seek the leave of the Court of Appeal to have the agreement, conviction or sentence set aside if the prosecutor was A and B. We had contemplated adding in any other ground on which it should be set aside. But it was here in 31 that it was pointed out that the right to appeal per se had not been provided for. Senator Sturge had actually brought that to the fore in some clear sense. We propose in the circumstances that we do some remodeling of the language of 31. And in the chapeau, that we separate out the concepts. We're proposing that 31 read, new subclause 1, it should say, upon application by the DPP, the court may set aside the plea agreement at any time before sentence if, and we maintain paragraph A and paragraph B as shown, which would be if in the course of plea discussions willfully misled, the prosecutor was willfully misled by the accused person or his attorney at law, and B, if the prosecutor was induced to conclude the plea agreement by threats, force, bribery, etc. And that we would also have one moment, the inclusion of any other grounds upon which the plea agreement may be set aside in the course by the court. Now, we had used the terminology here in the consideration out in the interest of justice. we had proposed in the new subclause 2 to delete words if the DPP appeals against sentence imposed in accordance with the plea agreement on the grounds referred to in subsection 1, and substituted with the words where in accordance with subsection 2 the DPP is granted leave to appeal to the Court of Appeal, and we'd continue. We're proposing to insert a new subclause 2, which would explain the flow that we're adopting. So we'd have the the new 1, as we have amended and which I will reread for clarity. We would come to 2, which would say the DPP may appeal to the Court of Appeal with leave of the Court of Appeal or a judge thereof against an accused person's conviction or sentence pursuant to a plea agreement where the prosecutor, A, in the course of plea discussion, was willfully misled by the accused person or his attorney at law in some material aspect, or B, was induced to conclude the plea agreement by threats, force, bribery, or other means of intimidation. And then we would renumber everything. So that's as actually spelled out. It's a little confusing when you try to do it in the drafting sense, which is where they say delete and substitute and do the other positions. But essentially what we're doing is providing for the right to appeal. We're saying that this is one of the cases where we should fetter the approach of the DPP by requiring for a leave to appeal provision. We're maintaining the narrow grounds for the prosecutor to make that appeal, that there was a willful misleading by the accused or induced to conclude the plea agreement by some form of threat or bribery, etc. The actual cleaned up version of what we propose is in the circulated marked up version of the bill that we have sent, and that should appear at page the unnumbered 21 and 22, following the page which is numbered, which is 20. So the clause as redrafted would read as follows. Upon application by the Director of Public Prosecutions, the court may set aside the plea agreement at any time before sentence if A, the prosecutor was, in the course of plea discussions, willfully misled by the accused person or by his attorney at law in some material aspect, in some material respect. B, the prosecutor was induced to conclude the plea agreement by threats, force, bribery, or by other means of intimidation or influence. Or C, there are any other grounds upon which the plea agreement may be set aside by the court in the interest of justice. The new subclause 2 would read, the Director of Public Prosecutions may appeal to the Court of Appeal with leave of the Court of Appeal or a judge thereof against an accused person's conviction or sentence pursuant to a plea agreement where the prosecutor, and again we repeat, A and B, in the course of the plea discussion was willfully misled by the accused person or his attorney at law in some material aspect, or B, was induced to conclude the plea agreement by threats, force, bribery, or any other means of intimidation or influence. And then in subclause 3, we would provide where in accordance with subsection 2, the DPP is granted leave to appeal to the Court of Appeal, the Director of Public Prosecution shall give notice of appeal in the form set out as Form 10 in the schedule within 28 days of the sentence passed. That in long form is the proposal that we suggest here. Madam Chair, I've just been speaking with the drafting team over my own observation that the subclause 2 proposed is deficient because we've not put the any other ground aspect. And if I could just explain, we were working on these overnight with the team working, etc. So that subclause 2 would need to repeat the ground in subclause 1, which is C. Now, it appears to be a little inelegant, and that's because we cleaved out. Subclause 1 deals with the application in the court before sentence, so we had to put those grounds. But subclause 2 separated out the appeal aspect. But I welcome through you, subject to that modification, the thoughts of the honorable senators.
Comments? May I just ask, the 1C, that sub C is to be repeated at 2C?
Yes, by
Yeah?
including it as a 2C. Mm-hmm. For consistency with 31, the words appearing at the end of C, which is in the interest of justice, we may want to delete that because we did not use that terminology in clause 30.
No, we didn't use it in 30. No. No, it was.
AG, in relation to the redrafted clause 31, this is envisaged to be an application that is going to be made to the court before whom the plea agreement is being entered.
Yes.
Right. I was wondering, and it may sound very, I don't mean to be very simplistic about it, but having regard to your version as drafted, which is to identify 2 specific grounds, and then to have an omnibus clause that captures, or the intention of which is to capture any other ground that may be advanced to set aside the plea agreement, and that is prescribed by in the interest of justice. I was wondering whether it wouldn't make or be more useful, to use your words, if we were not to excise A, B, and C, and simply say that upon application by the Director of Public Prosecution, the court may set aside the plea agreement at any time before sentence on any ground in the interest of justice for the purposes of not limiting the ground upon which you can set it aside, by capturing your intent, your policy position of allowing, in addition to A and B, the omnibus provision. But I would have thought my suggestion is grounded more in the fact that, as I understand it, subject to your correction, any court before whom a plea agreement is entered into will set aside any agreement between the prosecution or the accused in the interest of justice once the interest of justice so requires. I think it is more to say, as you would understand in civil terms, an inherent power that a court would have to dispense justice between the parties. So I was wondering if we are not doing an injustice to ourselves by specifying the grounds, when those are grounds that inherently a court hearing a criminal trial or hearing any trial in the interest of justice in civil law, we'd say, in fairness to the parties, would have an inherent power to set aside, and it would leave it open enough for the accused, the prosecution, or anybody to make an application where they think that something where they think that they've been wronged in some way, or some manner of unfairness has been perpetuated against them.
Senator Choate.
Thank you very much, Madam Chairman. I see the argument by Senator Ramdeen, but I think the inclusion of subsection C here really affords a court very wide powers to consider setting aside a plea agreement in the interest of justice. I thought that A and B really had been included as an indicator to the persons entering the plea agreement that the plea agreement was not sacrosanct, that it could be set aside if the accused person tried a fast one, or if the attorney at law tried a fast one to mislead the prosecutor. I thought that it was a very useful bit of language to be included in the legislation, so that when it is considered, automatically whoever is trying to make practical use of this will understand what's unacceptable. The subsection C captures the situations that we can't now contemplate and articulate, but it is grounded in the interests of justice test. So I think it looks fine as it is.
Madam Chair, I thank honourable senators.
Before,
I see you are correcting me. Yes, please.
I just want to ask if any other senator wants to raise any other issue on this clause, please. All right, Attorney General.
Madam Chair, thank you both senators for the excellent fulminations. Let me explain why. The unfettered approach was certainly one of the approaches which Senator Ramdeen has put out for us. When we reflected upon Section 15 of the existing law, and we went back to the policy discussions on the amendments to the law in the period 2014 come forward, Section 15 was felt to be a fairly robust piece of law which provided for signposts or mileposts along the way to the fact that there was no sacrosanctity in, if that's a malapropism on my part, right? That there was nothing sacrosanct in the plea agreement itself. It was subject to the review of the court. But also too, it provided in maintaining some of these signposts along the way for some of the grounds that you would have to go through on the leave stage. Senator Ramdeen had asked very importantly a while ago, what are you asking the court to consider in your leave application? And some of these grounds may be there. But I'm driven by the fact that there was no real complaint in 15, Section 15 of the existing law. Section 15 was a little bit differently worded because it included an inducement to conclude the plea agreement by conduct amounting to an obstruction of justice, which was a little bit hard to, how should I say, to make clear in the context of the interest of justice argument, which C has put in. I must add that usually subparagraph C as proposed following after A and B could fall prey to the ejusdem generis rule, but we're saved from that because we've put in the broader context in the interest of justice, which is different from clause 30 as we've put up above. In all of those circumstances, I'm of the view that the clause as circulated, the redrafted version, achieves the purposes of marrying policy, comment on the existing law, the need to put in a hurdle for the DPP by providing a leave position commensurate with the 1996 miscellaneous provisions amendments. And I don't know if members of the opposition in particular have any other contrary view to that, but our proposal is that the version as circulated should stand part of the bill. Okay.
This here.
Madam Chair, I'm going to ask you, in light of the phraseology at the end of what we've just proposed in the last words, in the interest of justice, if you would, for consistency, add that into clause 30, which we have already passed.
Clause 31. Attorney General, just one thing. In the amendments that were circulated, if you look at page 5, B, on the top in subclause 2, is that, you have it there as, are we putting it as subclause 3 in the bill with the track changes? Because it is a little...
Sure. I'll confirm now, Madam Chair.
This is what he says.
No, but the way I will put it.
Madam Chair, the reference to subsection 2 is correct, because we're inserting a new subsection 2. And then we will renumber accordingly, which is in paragraph D on page 5 of the amendments. What's missing from this would be in C, 2AB, we'd have to do some surgery here. We would be deleting the word or. We would be in paragraph A, subparagraph A, 2A, we would B, delete the full stop, include a semicolon, and the word or, and then we would insert subparagraph C, which would be the reference to the omnibus words that we used, ending in the words "in the interest of justice."
And then you have a sub 3.
And then we would have, well, no, the sub 3 would be the consequential renumbering.
All right. Honorable Senators, I ask you to bear with me because I'm actually going to read out the proposed amendment. So,
One moment, please, Madam Chair. Just let me get the drafting on the same page with you, because I think you were right when you said there would be a 3. Would you permit me a moment? Okay, Madam Chair, just to explain,
Yes.
what would appear as the new subclause 3 is what we amended first. So,
all right, so let me read it.
So it's correct
I
as
think I have
subject
it.
to the C, being
Yes.
inserted in C.
I think I have it, but I would ask all members to bear with me as I read it out to ensure that we're all on the same page with the amendments to clause 31, okay? So the question is that clause 31 be amended as circulated and as follows. 31(1). Upon application by the Director of Public Prosecutions, the court may set aside the plea agreement at any time before sentence if A, the prosecutor was, in the course of plea discussions, willfully misled by the accused person or by his attorney at law in some material respect. B, the prosecutor was induced to conclude the plea agreement by threats, force, bribery, or any other means of intimidation or influence. Or C, there are any other grounds upon which the plea agreement may be set aside by the court in the interest of justice. Subclause 2, the Director of Public Prosecutions may appeal to the Court of Appeal with leave of the Court of Appeal or a judge thereof against an accused person's conviction or sentence pursuant to a plea agreement where the prosecutor, A, in the course of plea discussions was willfully misled by the accused person or his attorney at law in some material respect. B, was induced to conclude the plea agreement by threats, force, bribery, or any other means of intimidation or influence. C, or C, there are any other grounds upon which the plea agreement may be set aside by the court in the interest of justice. Sub 3, where in accordance with subsection 2, the Director of Public Prosecutions is granted leave to appeal to the Court of Appeal. The Director of Public Prosecution shall give notice of appeal in the form set out as Form 10 in the schedule within 28 days of the sentence passed. Those in favor say aye. Aye. Those against say no.
Madam Chair, the drafters are just adding one small amendment. Because of the inclusion of C in subclause C, it is just that in the chapeau, in the new subclause 2 as read by you, we insert a dash. We insert a dash after the word where. The words appearing the prosecutor would repeat in the first words in A and B, and that's it. So it would resemble what we did in the previous paragraph. So if I could just read for completeness sake, only this part, in the new subclause 2, the words would read like this. The Director of Public Prosecutions may appeal to the Court of Appeal with the leave of the Court of Appeal or a judge thereof against an accused person's conviction or sentence pursuant to the plea agreement where, dash, A, the prosecutor, in the course of plea discussions, was willfully misled by the accused person or his attorney at law in some material respect. B, the prosecutor was induced to conclude the plea agreement by threats, force, bribery, or any other means of intimidation or influence. Or C, there are any other grounds upon which the plea agreement may be set aside by the court in the interest of justice.
Honorable Senators, I will reread subclause 2. And I ask you to bear with me because this forms part of the record and we have to be careful about it, okay? So I'm going to reread clause 2, the proposed clause 2. The Director of Public Prosecutions may appeal to the Court of Appeal with leave of the Court of Appeal or a judge thereof against an accused person's conviction or sentence pursuant to a plea agreement where A, the prosecutor in the course of plea discussions was willfully misled by the accused person or his attorney at law in some material respect. B was induced the prosecutor was induced to conclude the plea agreement by threats, force, bribery, or any other means of intimidation or influence. Or C, there are any other grounds upon which the plea agreement may be set aside by the court in the interests of justice. Yes? Honorable Senators, the question is that clause 31 be amended as circulated and reread and further amended as reread to honorable Senators. Those in favor say aye. Aye. Those against say no. If the ayes have it, honorable Senators, the question is that clause 31 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 31 as amended now stands part of the bill. Just one thing. Attorney General, you indicated that you wanted to go back to clause 30.
Yes, Madam Chair, in light of the amendment that we just did to cause a small inclusion.
What is the inclusion?
Sure. The revisiting I'm requesting is that in clause 30, 1D, where we added the words, there are any other grounds upon which the plea agreement may be set aside by the court, that we insert before the full stop, in the interest of justice. And that's to make it in keeping and consistent with what we just did in clause 31. Revisiting. So, Madam Chair, in the circulated amendments, specifically, it would be in paragraph A that we amend the paragraph D as shown by
No,
including...
remember, Honorable Attorney General, you withdrew those amendments as circulated.
Yes,
So that what we're going to do is I'm going to put it that we revisit clause 30, and then we are going to simply insert the words.
In the interest of
yeah,
justice. Thank you.
yeah. Okay? Yeah. Honorable Senators, the question is, no, we have to say it. Sorry to hit you.
Clause 30 revisited.
Honorable Senators, the question is that clause 30 stand part of the bill.
Madam Chair, we propose that in 31D, sorry, which should now just read as 30D, that we insert at the end of the subclause D the words "in the interest of justice."
By the court. By the court.
By the court in the interest of justice.
By the court.
By the court in the interest of justice, sorry. After the word "set aside," insert the words "by the court in the interest of justice." Thank you.
So, Honorable Senators, the question is that clause 30 be amended by inserting the words at subclause D, after the word aside, inserting the following words: by the court in the interest of justice. Those in favor say aye.
Aye.
Those against say no. The ayes have it. The question is that clause 30 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 30 as amended now stands part of the bill. Honorable Senators, I think at this stage we should suspend. We should suspend 1 hour. General. Resume in 1 hour's time. Actually, 1:47, 2:47, 3 o'clock.
Okay, sure.
All right, Honorable Senators, we will suspend and we will resume at 3 p.m. When I come
Right
back.
after. Go back to Senate.
Yeah. So the committee is suspended until 3 p.m.